SJC-12835, Commonwealth versus Jerome Morris.
Okay, Attorney Neves, looks like you're in position.
I am.
Hi.
Thank you. Good morning. May it please the court, Catherine Neves on behalf of the defendant appellant, Jerome Morris. I'd like to start with a quote from this court's case in Commonwealth versus Tavares about the scope of the wiretap statute. Quote, "The wiretap statute is framed largely in negative terms. Surreptitious interception of any oral communication by any person, private citizen or public official, is proscribed, except as specifically provided in a few narrow exceptions." The motion judge in this case resolved in Mr. Morris's favor conflicting evidence at the motion to suppress about whether Mr. Morris was told or whether he knew he was being recorded.
Right.
And he found that Mr. Morris was not advised that the interview was recorded. I also do not find that he was on constructive notice that the interview was recorded. Under the Massachusetts wiretap statute, that's a secret recording, that's an interception.
And you say that despite the holdings in DG Bantista and our other cases that say, come on, start recording these interviews now.
Of course, all you have to do is tell them that you're recording them. And this court was very careful in DG Bantista. This court wanted interviews to be recorded because they felt that you felt that it would be the best way to preserve statements and that it would be best for all parties involved. And the court, in carefully coming up with the remedy that if there isn't a recording, there's a cautionary instruction given, the court rejected a rule of exclusion, considered it and rejected it, saying, we can't do that because sometimes a suspect will not want to be recorded, or a suspect will want to turn off the recording halfway through. Mm-hmm. But at no point in DG Bantista did this court advocate that the police should violate the wiretap statute by secretly recording interrogations. And I think what you have in this case—
In Gordon, they didn't tell them they were recording the police station booking, did they?
That's correct, Your Honor. And I think that that's largely distinguishable, and I think this court did distinguish it, and it's the same here in Commonwealth v. Hyde. In that case, it was a motorist who secretly recorded police officers who stopped him in a traffic stop, and he was prosecuted for violating the wiretap statute because he was secretly recording the encounter. And he made the argument that this is just like Gordon. These officers are doing their public duties, and there's no reason why I shouldn't be able to record it. And what this court said is, there is no reasonable expectation of privacy requirement under the statute. So it's not a question of whether the police officer, had a reasonable expectation that he wouldn't be recorded. The question is whether he knew. And this court said, all you had to do was tell the officer you were recording him.
But I still don't understand how Gordon is, again, Gordon wasn't told.
Well, I think, yeah, Your Honor.
Gordon and Hyde are inconsistent with each other, is that what you said?
No, they're not.
So how do you reconcile them?
Yeah, this court said it's not like Gordon, because what we said in Gordon was videotaping of the booking procedure did not seek to capture the defendant's speech or thoughts on a subject. It was used to gauge their manner, to gauge their sobriety. And so this court carefully distinguished Hyde, saying, no, you motorist were deliberately secretly recording the officer because you were going to bring a complaint about the behavior.
There has to be some secrecy, right?
Exactly. So I think secret means you don't know. That's secret. So, and I think
And you think Ashley is just wrongly decided?
I'm afraid it cannot be squared either with the wiretap statute itself or this court's precedent in both Hyde and Commonwealth v. I believe Jackson, where the court first said we would be eviscerating, I'm paraphrasing, the carefully chosen words that the legislature used if we imposed onto the statute a reasonable expectation, requiring a reasonable expectation of privacy for the speaker. And I would ask the court to look at the difference in the definitions between the Massachusetts wiretap statute and the federal statute. The federal statute does have a requirement that the speaker have a reasonable expectation of privacy, and it defines an oral communication as, quote, any oral communication uttered by a person exhibiting an expectation that such communication is not subject to interception under circumstances justifying such expectation. Our wiretap statute defines an oral communication as speech.
So how is this going to work in the real world?
It works in the, yeah,
So the cops are responding to an emergency?
no. Oh, in this case?
No, but I mean, we want the police to turn those video cams on, don't we?
Oh,
So-
sure.
And they're not going to always be able to say, "Hi, bank robber, I'm turning on my recording now." Are they? You really want us to create that rule?
I'm afraid the legislature wants you to have, I mean, the legislature has spoken.
You think they want us to,
I think-
basically, every time the police turn on that video cam and they don't say, "I'm turning on the video cam," it's, is that a criminal act by them? I can't remember. Is there criminal
Well, I mean,
penalties associated?
of course, technically it is. I don't know who would prosecute the officers. But I think the more important issue is that if a police officer unlawfully records in violation of the wiretap statute, there's a suppression remedy. And as to whether you need to,
We don't get to limit it that way, right? If there's a criminal penalty associated with it, aren't you?
no, that's true, but that's what the statute provides. And this court has said on several occasions that the statute is clear and unambiguous. And, you know, it's this court's review of the motion judge who said this did not need to be suppressed because Mr. Morris did not intend to keep his conversation private.
But there's a difference, isn't it? Isn't there a difference between what Justice Kafker just described, where you have a police officer with a body cam that is likely obvious to whoever the police officer is encountering?
Right, you could, yes, there could be, yes, thank you, Your Honor. There absolutely could be the determination that you are on constructive notice. And certainly Mr. Morris in this case, and I think that, you know, when this interrogation happened was 2014, 10 years after D. Giambattista had been decided. And I think that, you know, the normal practice in most, a lot of police stations is just, if you've got a sign on the table, you're being recorded. This court has a sign when you come in, I notice, telling whoever walks in that you are on camera, you are being recorded. So in this case, there was no sign. And the camera, there are pictures in the record, it is picture day, is about the size of a fist, and it looks like a motion sensor. And the motion judge here said, no, in this case, I think in many cases, and which is why Ashley, even though the reasoning was wrong, the outcome was right. In that case, there was a visible camera in the room, there was a sign on the table that said you're being recorded. In this case, there were neither of those things. Mr. Morris testified, I didn't know there was a camera in the room. Nobody told me there was a camera. I didn't see a microphone or a camera. There was no sign. The motion judge credited Mr. Morris's testimony. So yes, absolutely, you've got to record, you know, he presses the button, you know, it's there. And I suppose there's also the aspect of, are you trying to capture speech or are you trying to capture action? And I think that is the Gordon, that can be a distinguishing factor to lean the court in that hypothetical toward Gordon. You're not trying to capture somebody's words or thoughts on a particular subject. So I think.
And if this, there would be no problem, though, with the officers testifying as to what the defendant said during the interview, right?
I think this court in Jerome said that if the officer, and that's cited in my brief, that if the officer's testimony or the person, not necessarily an officer, the person who was the other party to the secret recording, has an independent recollection without looking at the unlawful recording, they may testify to their recollection. Now, true, but if they can't, if they have to look at the tape to recall what the conversation was, then it is evidence derived from the unlawful recording, and they cannot.
Is there a difference between refreshing one's recollection and remembering based on what they've seen?
I think you have, and I think in Jerome, there was a discussion about that, and I think there was an appeals court case, Downey, where this was an issue as well. And there has to be a very careful assessment in the trial court about what's an independent recollection and whether the officer or the individual has looked at the recording to refresh the recollection. If they have, it's not usable, because suppression means you suppress all evidence, all idea that the tape ever existed. So is he, you know, are the officers going to have an independent recollection? I don't know, but that's why you don't secretly record. You put a sign on the table, you make sure the camera is visible. You say, and I know that this was not at the suppression motion, Trooper Short, one of the two troopers who conducted the interrogation here at trial, and this is at volume 10, pages 25 to 27, he admitted, you know, there's nothing, you know, that he wasn't notified, and asked, and that probably violates your normal practice, doesn't it? Yes. In almost every case you interview these people, you say on the tape, so it's memorialized, sir, our policy is to tape these. You're being taped, you're being videotaped as well, right? Yes. We agree that good police practice is to do that, right? Yes. And with another witness in this case, they did it. That's on the transcript as well. With Mr.
Right.
Morris, you didn't, correct?
So
Correct.
with that in mind, and thinking about what the judge said, that it did not seem to be an intentional failure to notify him, correct? He did not find this was secretive on purpose.
No, I think secret just focuses not on the intent of the recorder, other than the recorder has to intend to record.
So you're not alleging that there's an intention on the behalf of the trooper, are you?
I think
Or are you?
I think you can draw
Well,
that
are
inference.
you though? I mean, you can, are you?
Well, I guess my point is, what's important is, and I'm happy to answer that, but I think what's important is that what matters is what the speaker knows. If the speaker doesn't know, then it's secret. I think in this case, so even if they forgot, so Trooper Coppenrath testified, I absolutely did it. I did it when we were out in the hall. I definitely did it, and the trooper who brought him up probably would have overheard it. Was it recorded? I don't know. Unfortunately, I think the reason that the motion judge perhaps didn't credit that is that Trooper Short, who brought Mr. Morris up, said that he didn't recall telling Mr. Morris, and he didn't hear anybody else do it either. So even if it's something that you normally do it, you almost always do it, you forgot to do it, the problem is it's still secret under the wiretap statute. It's a secret. It's a secret recording. So the motion judge here he found as a fact, essentially, that it was an interception. But he found that it wasn't suppressible, it wasn't a problem because Mr. Morris didn't intend to keep his conversation private, which of course this court has, I said already, in Hyde and Jackson, there is no requirement that the speaker have a reasonable expectation of privacy. The harm is the secret. So I think, the simple answer is that's why you just put something in place so you never have to. I mean, I think in this case, you could certainly draw an inference that perhaps it might have been nicer for Mr. Morris not to, have a looming camera on him. The evidence in this case against him is largely his statement in which he confesses to shooting the victim in this case. So I think the concern that was raised in amicus briefs in the D. Giambattista case by police officers, that the concern is that if you tape record people, they won't talk. Especially in a case where your evidence is not so strong, maybe
Well, he said he was going to talk. There was no Miranda violation. They said clearly, here's your time to tell your story, and he told his story.
True.
It's incredibly speculative just to say, well, if there was a camera. I get your literal interpretation of the
Yeah.
wiretap statute, it's well
Yeah.
taken. But I think we get into a
I
little bit of
said
speculation.
there's an argument to be made, but yes.
I think your literal interpretation is your best argument, right?
I don't know. I mean, I know that I don't always think that I'm being recorded if I see a camera in the room, but I think it would affect how I say things, what I say. I don't know. But in any event.
Is there a difference between surreptitious and not getting your consent?
Well,
there seems to be.
surreptitious, yeah, isn't in the statute. That's been sort of used in
but
the
it-
case
it's-
law.
But it's in Hyde too, everything
Yeah,
uses the word
It's our
surreptitious.
interpretation of the,
what secret
Yes,
means.
Of
yes,
secret, right?
yes.
So
Surreptitious.
Isn't that the key, is that we have to figure out what's secret, like when you come in here and you know that you're going to
Right.
be on, even without that sign out there, are we secretly recording you? Because you know the social law, you're a lawyer, you can watch yourself on social
Right.
law after this. Are we secretly
Right.
recording you without that little thing there?
No, because I'm on constructive notice, and you could prove that I've argued here before, that I've watched arguments here. You can prove that I've got constructive notice.
And you're and someone who's in a police station after he's been given Miranda warnings, he doesn't realize that this isn't surreptitiously recorded. I mean, he's being.
I don't think I want to live in a country where I'm being secretly reported
Well,
by
you're
the
not, well,
police,
but you're, when you
know,
talk.
I mean, I think,
But
I
don't you want?
those are two
when-
different things.
But when you're talking to the police, you in a police station after you've been given Miranda warnings, you really think that this is surreptitiously recording him? If you don't say you're being recorded.
I think you know your words are going to be used against you. You've got the Miranda
Well,
warnings.
don't you want your words accurately
Well,
reflected?
I don't know. The wiretap
I would.
statute.
You wouldn't?
Well, sure, but the wiretap statute says, unless you know, it's secret.
It doesn't immunize, and Gordon doesn't immunize the entire police station. So for instance, you couldn't bug the attorney room,
Right.
right?
Right.
So that would be a
Right.
surreptitious.
Right.
If we say, Ms. Neves, you can talk to your client now in this conference room, and there's a,
Right.
there's a
Yeah,
plug under
so
the
like a
table.
wire, right, I get
it would-
that.
So the whole
Right.
entire,
Right.
we don't draw lines around the entire police station, of
Right.
course.
Right.
But the distinction, I think Justice Kafka, is the difference between that and not informing someone of their Mirandized statement is vast, correct?
I'm sorry, I didn't follow.
There's a big discrepancy between bugging the attorney room
Sure,
and,
but it's the same thing. It's
the-
an
and you-
interception. It is. You need to know, under the wiretap statute, you
Right.
need to, if it's secret.
What about any of the signs, the sign on the garage door and the fact that the defendant had been in this booking station before and knew he was recorded when he was being booked and
I-
had some experience? I don't know if he'd given and had been interviewed before, but
That's the point. There's nothing in the record to indicate that he'd ever been interviewed before.
and Judge Moriarty discounted the garage.
Discounted the garage. He said that's not enough. And yeah, there's plenty of
But
evidence.
we'd have to find him clearly erroneous if we disagreed with him.
Exactly.
Right?
I think, yeah, and I think that, he saw he watched the videotape. There's some argument that at one point, Coppenrath points and says that people are going to hear you. The judge saw that and obviously did not find that persuasive as well.
Oh, so the Commonwealth argued when Coppenrath he was pointed to the camera?
Right, but not at the motion to suppress. On appeal here, it's argued. But obviously, the motion judge did not find that persuasive. He watched the tape. He credited Mr. Morris's statement that I did not know. I didn't know. I mean, and the issue of consent, I just want to get back to what you said about that.
I'm trying to, yeah, I'm getting confused now about, in Hyde, they secretly recorded, right? They weren't out there with their, like, so I just want to make sure that when the cell phones now, when you're.
Yes.
Everyone out there
You know.
shooting everything, are they?
Right, yeah.
Are they violating that too?
No, if people know, I mean, if you see someone, and it's obviously recording, you're on actual,
They haven't told me. I don't know. Well, yeah.
But that's the difference.
But if we
You-
meet on the street and
you
I
just-
have my iPhone in my pocket and I
There.
turn it on, I'm secretly recording you.
Yes, because you don't know. It's either somebody tells you because they're in charge here, and the phone looks, the camera looks like a motion sensor, and there's no sign, so they just need to tell you, this is recording you. Or there's a sign, and that gives you the constructive notice, or they're holding up the phone, you know, they're recording you, you absolutely know. And as to the issue of consent, I just want to make sure.
And do you need to know like, so a police officer is arresting someone in public, and there are 40 people nowadays taking their cameras out and monitoring that. Does the police officer need to know that just collectively, or are all those 39 people that he sees a couple of them, but he doesn't see the other 20? Are they also about to do time?
I think that,
Know where we're going, you know?
well, I think the wiretap statute tells you exactly where we are and where we've been since 1968 when they changed it. And that, you know, if someone doesn't tell you, or if they hide it, or if it's obvious, that's the difference.
What do we glean from the preamble to the wiretap statute about the purpose of it and how we interpret it?
Yeah, you know, we are very concerned back in 1968 about electronic surveillance, and that these devices are getting better and better. And, you know, we're concerned about secret recording of people. But at the same time, we don't want to impede police officers when they're investigating designated offenses in connection with organized crime. And organized crime is very specially defined as, you know, conspiracies, groups of people who are engaged in trafficking illegal drugs or services, you know, illegal substances or whatever. They're engaging in illegal business. So we are putting out this statute. We don't want it. We don't want any secret recording. You can use these devices, but no secret recording. And the police, you too, if you're going to do this, you have to do it in very, very carefully circumscribed circumstances. I guess I'll rest on my brief on the other two issues that I raised. Thank you very much.
Thank you. Okay, Attorney Nguyen.
May it please the court, Mary Nguyen, on behalf of the Commonwealth. There is a presumption that a defendant is aware that a police interview is preserved. That's in footnote 9 in the Hyde case, where it says, quote, "We presume that when police interrogations are electronically recorded, the suspect is aware that the interrogation is being preserved." But more than that presumption, what we have in this case are the words and conduct of the defendant, which Jackson talks about how you can infer one's knowledge.
It doesn't, how do we deal with the fact that the judge makes a contrary finding of fact on that, right? He says there's no constructive knowledge here, right?
So
Am I misremembering, or?
I'm going to just, if I may, refer to the judge's findings in that regard. So he does say, state, "I do not find that he was on constructive notice that the interview was being recorded," but also in the second to last sentence, he uses some language from Ashley and talks about how it's obvious from the circumstances in this case. And I would suggest looking at the defendant's conduct and his words in this interview,
So,
that
yeah,
he was aware.
Okay, you're going to give us his conduct and his words that give us that inference?
I think so, and I think Jackson talks about how that's a sensible approach, looking at defendant's words and conduct, and I do indicate in my brief, you know, the fact that he is asking for a reduction in the charge about the person listening. So the police are very clear that they're...
What did you say there? He asked for a reduction in the card?
So the defendant inquires if the, quote, person could, quote, drop the charge to something less.
Person, and you're saying that refers to him referring to who's watching?
Correct. So that's shortly after the lieutenant indicates that there are going to be the people, that the people would be listening to what the defendant had to say. That's when there was the pointing. But I think more importantly is the fact that the lieutenant is is making it clear to the defendant that that the people are going to be listening to your story. And then the defendant's response, his words are, will that person drop the charge to something less? And then there's also the defendant's reluctance to name certain people during the interview.
So are we going to find that the judge's finding there's no constructive knowledge is a clear error? Or is that what you're asking us to do, or I'm confused?
I'm not,
We'd have to find that he was under constructive notice and that Moriarty was wrong.
I'm sorry. So,
We would have to find a clear error. If we draw this inference from the people listening, we would have to say he was under constructive knowledge and the judge made an error, correct? There's no
Yes.
other way
yes,
to
but-
come to that conclusion if we do, unless we draw that inference or make that finding.
yes, and so I think to support that finding also is the defendant's experience with the criminal justice system, and in particular, the Brockton Police Department having,
But how does that help you unless there's evidence that in his prior instances he was recorded?
I'm sorry, Judge?
If it's just that he was arrested by the BPD a bunch of times, what's that do? You'd have to have evidence that he was taken to that room and recorded in the past.
Sure.
And you don't have that, right?
So I think where I was going in my brief was that, for example, the sign on the garage door, I understand what the judge's ruling was, but the point that I was trying to make is that it's demonstrating that there was nothing deliberately surreptitious. So as Your Honor had indicated, it's about whether it was a secret here, and I think the evidence is clear that there was no secret, that this interview was being preserved for court. I do go at length about just the Miranda waiver itself.
So you don't buy the defense counsel's argument that if something's secret, that means that the person who is speaking doesn't know. You don't, that's
so-
not your definition of secret. Because the argument on the other side is surreptitious is different from secret. So you may be recording me. If I don't know it, then it's a secret from me, even if you're not trying to keep it away from, keep it from me.
So I was sort of confused by that argument, sort of the distinction between surreptitious and secret, because the way that I read that is it's the same.
Well, it's not if the defendant doesn't know for whatever reason versus if the defendant doesn't know because you're hiding it.
So, well, that's kind of why I suggested, although I understand the judge's ruling about the notice on the garage door, that's where I say it demonstrates that it's not deliberate here. There's nothing deliberately surreptitious. There's no secret here. He's saying the police are saying that people are listening, and then to show the defendant's awareness, he's asking for that reduction in the charge. He's reluctant to name certain people. So I do think that the Miranda waiver is also indicative of the fact that there was no secret that the interview was being preserved for subsequent use in court.
Counsel, you continue to use the word preserved, which I find to be really cagey, because preserved could also mean that you know that they're writing down your statement or contemporaneous notes of what you're saying. So that could preserve that for trial, but the issue is whether it's being the way it's being preserved. And so if the way it's being preserved is by recordation, and the wiretap statute says that the person has to know. Again, going back to the standard of review, how do we conclude that Judge Moriarty clearly made an error here?
So I will say, I think that the Jackson court talks about how they are saying it's unnecessary for any further requirement that the person recording the conversation confirm the caller's apparent awareness by acknowledging the fact of the intercepting device, and that's where they talk about the sensible approach by looking at the caller's words and conduct. But I use preserve because that's the word that was used in Hyde in that footnote that I referenced, which is we presume that when police interrogations are electronically recorded, the suspect is aware that the interrogation is being preserved. Ashley also talks
Right,
about...
but that footnote presumes that they know it's being electronically recorded. You're giving us a circular argument right now, because you still have to go back and say, you know it's being recorded because we told you it's being recorded, so you know it's being recorded. So we still have to begin with the fundamental first premise, first domino. So what's the first domino here?
Well, so I think, if I recall correctly, the Ashley court sort of talks about this distinction without, or a difference without a distinction, if I'm saying it correctly, because it's not about the recording, right? It's about the interrogation itself. I can find that section, and hopefully that will answer the question. But so the quote is, the recording is not for the investigative purposes. So while the interrogation is for investigative purposes, the recording of it is not. That is, it is the interrogation and not the recording that is investigative. The purpose of recording the interrogation is not to gather evidence, but to record the evidence gathered by means of the interrogation. And then I talk about it as well, but the Ashley court talks about the policy behind.
Are you reading from a case? Are you reading from Jackson there? I couldn't tell what you were just doing.
That was from the Ashley case.
Okay, that's
at
Ashley.
footnote 15
okay.
on page 762. But so the Ashley court talks about how it was obvious during the interrogation from the defendant's conduct, right, in his words, that he didn't intend to keep the statements private, and that's where I talk about how he knew that it was being preserved for court. And I see how I don't think it's a circular argument, because I think that, and I use the word preservation and memorializing, Ashley court uses memorializing the interview.
That's a pretty fine distinction between the recording and the interrogation. Aren't they one and the same? I mean, I don't see how you sever them in that way. I mean, you're recording it as part of the interrogation, aren't you? I mean, we're slicing the bologna pretty thin there.
It's so the Ashley court tries to just discuss this, if you will, this distinction. And the policy behind DJ Baptista is that we want these police interviews recorded.
Mm-hmm. I guess if you make this argument, I guess it goes back to Attorney Neves. That would seemingly read into the statute the reasonable expectation of privacy, wouldn't it? Because if you're saying it's a distinction without a difference, because you're saying whatever it is you're saying, whether it's being recorded or not, and you know that whatever it is that you're saying could later be used and repeated in court, so therefore it doesn't matter whether or not that you knew it was recorded or not. Doesn't that infuse into the statute a reasonable expectation of privacy?
I don't think that's what the Ashley court or the motioners in this case was saying, and I do comment on that in my brief. I think that they were taking the circumstances in their case. I don't think they were making a blanket, there needs to be a reasonable expectation of privacy. All conversations in the interrogation room at a police department, you need to have this reasonable expectation of privacy. I don't think that was being said by Ashley.
It's an interpretation of the word secret, correct, or surreptitious?
I'm sorry, Judge?
It's an interpretation of the word secret or surreptitious. So if the defendant is given a statement to the police, he's not keeping his word secret.
He's not.
Keeping his word secret, correct?
Correct, he's not keeping his words. It's not a secret. A police interrogation is not a secret. Going back to hide that footnote, there's that presumption. But here in this case, even beyond this presumption, there's the evidence from his words and his conduct together with waiving his Miranda rights, which is not in dispute.
May I take you in a bit of a different direction and just assume, I'm not saying this is what will happen, but just assume that we conclude there is a violation of the wiretap, or that there's a reason this confession should be, or the interrogation should be suppressed. What evidence do you have remaining if that happened?
In this case, if this,
Yeah, this one.
it was a major piece of the evidence, the confession, certainly. And it was also, the defendant also used that statement to support his defense. The defendant didn't take the stand as is his right. And certainly he was relying on statements made, his version of events.
Was that also used in cross-examination, the statements did the defense attorney use the statements from interrogation and cross-examination of any of the witnesses?
Did he use?
The statements made by the defendant during the interrogation, did the defense attorney use those statements in cross-examination of any of the other witnesses?
That I can't say for sure as I stand here, but I do know in his opening, he pointed right to the statements and said, you know, the defendant's state of mind is going to be crucial in this case. Listen to his words. It is not the words of a murderer.
The statement played such a role in the trial that a new trial would have to be ordered if it was suppressed, correct? You can say yes.
Because there's nothing left, really.
There will not be much left.
Right, it was used by
Yeah.
both sides. It was pivotal to the trial.
For both sides, they both really utilized the statement.
Right.
Obviously for self-defense, the defendant was relying on that for self-defense. And then obviously the Commonwealth had a different spin on that. But essentially, it is the Commonwealth's contention that the recording was not made secretly. It wasn't an illegal wiretap. It was not an interception within the meaning of the wiretap statute. And I know that we've discussed sort of the difference between secret and surreptitious. I don't know if there's a difference between secret and surreptitious.
But why isn't it an interception?
So an interception is a secret recording. Interception under the statute means to secretly hear or secretly record. And in this case, I'm suggesting it wasn't secretly recorded. As I indicated before, the lieutenant was saying the people are listening. The defendant was aware.
But doesn't that bring us back to Justice Gaziano's question about Judge Moriarty's finding? We'd have to conclude that was a clearly erroneous finding about the secret
The constructive
recording.
notice?
Yeah, the constructive notice and
I'm having a hard time with that one because although I acknowledge he says constructive notice, in that last paragraph, he also talks about how it was obvious during the interrogation that, that he knew that what he was saying could be and would be used against him in court. So I'm having a hard time with that because...
That's a legal conclusion, though, because he's drawing his legal conclusion based upon Gordon and Ashley, correct?
Correct. Did anyone, were there any other questions on the wiretap issue? Mm-hmm. Okay, so regarding the second issue with the statutory right to a telephone.
There, Moriarty made the finding you wanted. He found it wasn't intentional.
Correct.
So you think he was right in that one?
He did, so yes, in that, so with respect to the second issue, here, the Commonwealth's contention is that the defendant has failed to show that that finding was plainly wrong. And then, the information given to the defendant by the detectives here regarding his other rights, together with his prior experience with the criminal justice system, certainly points to support of the judge's conclusion that there was no evidence of an intentional denial of the defendant's right to use the telephone in this case. And then the judge relies on Rodriguez. I think that is a good case, as well as Walker, to suggest that it's not misplaced to consider the defendant being informed of these other rights, along with his prior experience in the criminal justice system. And then here I do note, and that he has exercised his statutory rights to use the telephone at this very same police station in Brockton 10 times before. The Commonwealth's contention is the defendant here has not met the burden to establish an intentional violation of that statutory right to use the telephone call. Now, regarding the third issue, these are post-Miranda statements. So the prosecutor commented on a very significant omission, I would suggest, regarding the defendant not telling the police he saw the gun in the car. I do cite to quite a few cases, including Donovan, that stand for the proposition that by talking to the officers on his own volition, the defendant waived his Miranda rights, that he doesn't argue to the contrary. So what the defendant thereafter chooses to say or not say to each officer on the subject could properly be commented on by the prosecutor to expose inconsistencies, and that's precisely what the prosecutor did here. The defendant here did not remain silent, and it was certainly not off limits for the prosecutor to be able to comment on that very significant omission. And I do note that on August 31st, there was a motion for new trial filed in this case pursuant to Moffitt, where he advances 3 claims of ineffective assistance of counsel. Do any of your honors have any questions on that Moffitt claim?
I don't think so.
I would rest on my brief, and I'd ask that you affirm the convictions. Thank you.